Hello, and welcome to Legal Actions and Contractions, a discussion on pregnancy discrimination and accommodations for Alaskan businesses. My name is Alex Reuter, and I am the Special Projects Attorney with the Alaska State Commission for Human Rights. Now, what is the State Commission for Human Rights? Well, sort of like the civil rights agency of the state. We're given the mission to eliminate and prevent discrimination for all Alaskans. We are governed by 7 commissioners appointed by the governor and confirmed by the legislature. Currently, that is Zachary Gottschall, Mae Marsh, William Craig, Jesse Ruffridge, Becky Carrillo, Sheila Cernich, and Doreen Lorenz. We enforce AS 1880, the Alaska Human Rights Act, and this basically charges us with investigating claims of discrimination that we receive. If it seems like discrimination has occurred, we will then conciliate the case, or, if it's needed, present case at trial. And we advise the public on the state of discrimination law, and when need be, conduct trainings such as these. Today we're going to talk about the Alaska State Commission for Human Rights, ASHA for short, and federal pregnancy coverage, employment and reasonable accommodations needed for pregnant employees, humping requirements and places of public accommodation, and inquiries into parenthood and pregnancy and financing and housing, sort of covering all areas of pregnancy discrimination that the State Commission for Human Rights has coverage over. The Alaska State Commission for Human Rights enforces Alaska law that forbids discrimination on the basis of pregnancy, parenthood, or marital status in the realms of employment, as covered by AS 1880-220. An example of this would be refusing to hire a pregnant applicant for a job that they are qualified for. Places of public accommodation under AS 1880-230. An example of this that we've seen is refusing to sell a car to a pregnant person on the basis that they are quote-unquote hormonal. Housing under AS 1880-240. An example of this would include refusing to rent to an unmarried pregnant tenant. And financing under AS 1880-250. An example of this is refusing a loan to a pregnant person out of concerns that the pregnancy will impede their ability to pay back the loan. So a number of federal regulations also govern the treatment of pregnant women in the workplace and go beyond normal ASHA coverage. These include the Family and Medical Leave Act of 1993. You may have heard it referred to as FEMLA. This mandates unpaid leave coverage for certain pregnancy-related issues. We're not going to get super into FEMLA today. That's a pretty well-trodden territory. You may have seen requirements for, things like 12 weeks of unpaid leave for a mother following a childbirth, things of that nature. But 2 pieces of legislation that definitely affect this conversation are the Providing Urgent Maternal Protections for Nursing Mothers Act of 2010, more commonly referred to as the PUMP Act. This mandates that workplaces provide safe areas for nursing mothers to pump breast milk. And the Pregnant Workers Fairness Act of 2023. Now, this is a hugely important act that has really changed the landscape of pregnancy discrimination coverage in the workforce. So since this is so new, we really want to cover this topic. This includes requiring reasonable accommodations to the known limitations of a pregnant employee unless this would impose an undue hardship of the employer. Now, if you picked up that is some very specific and complicated language, do not worry. We're going to spend a decent amount of time picking that apart and explaining what that all means. But this was put in place to fill in gaps left by the earlier Pregnancy Discrimination Act of 1978. So, accommodations for pregnant employees. Again, this has just changed with the Pregnant Workers Fairness Act. Why did this just change? Because Congress did not view the previous legislation as providing enough coverage to achieve its goal. That goal is to keep pregnant employees working as much as possible by providing, again, reasonable accommodations, that's part 1, to an employee or applicant's known limitations, that's part 2, relating to or arising out of pregnancy, childbirth, or a related medical condition, part 3, unless said accommodation would impose an undue hardship, part 4, upon the employer. So, let's pick this apart bit by bit, because this can be very confusing. So what is a reasonable accommodation? A reasonable accommodation is an adjustment or modification to work environment or performance, including temporary suspension of some essential functions of a job. So examples of these can include letting an employee sit down at a cash register. Sometimes we'll get employers who want all their cashiers to stand up. Letting someone sit down instead of standing up is almost always going to be a reasonable accommodation. Modifying an employee's duties to exclude heavy lifting. Many pregnant people get advice to not lift over, say, 20 pounds for the third trimester. This modification would be ensuring that they can comply with that doctor's request. Limiting the height an employee must climb up a ladder due to, say, pregnancy induced vertigo. Providing unpaid leave to attend doctor's appointments. Supplying an employee with maternity sized work uniforms. And allowing an employee to park closer to work facilities. That way they can, reduce the amount of time that they have to walk while pregnant. So, what is meant by a known limitation? This is the second part of the PWFA. This just means that the employer has knowledge of potential challenges in the workplace faced by the employee. All we want to know is just make sure that the employer is aware that there could be some problem that the employee is facing. The goal here is just an interactive process between the employer and the employee. There's no specific way this has to happen. There are no magic words. It can be just a quick, chit chat aside. It can be a text message. It can be over email. There's no formal reason that you have to ask or way you have to ask it. But an employer can, in some instances, request medical documentation to back up that this known limitation exists. So, that wonderful legal phrase, when is it reasonable? It's reasonable, well, they always say when a reasonable person would do it. So let's begin by saying, when is it unreasonable to seek documentation? When can an employer not say, I need a letter from your doctor? First, when a condition would be obvious or known. So, say, for example, an employer says, hey, I want proof that you are pregnant, and a person is, say, well into their third trimester, very visibly showing, that would be unreasonable for an employer to seek documentation. A employer cannot request a medical doctor's notice if it is a request to pump at work. You cannot seek documentation if it is a request to carry drinking water while pregnant. You cannot seek medical documentation if it is a request to take additional bathroom or snack breaks while pregnant. You cannot seek documentation if it is a request to sit or stand while pregnant instead of whatever the normal policy is. And you cannot seek documentation if the documentation would not be sought for other limitations. Let me explain here. You cannot put someone who is pregnant to a higher standard than you would for some other condition. Say, for example, if someone had broken their leg and you would not request proof from a doctor that they can't perform certain tasks, if you require proof from a doctor for a pregnant person to prove that they cannot perform similar tasks, you are now treating that pregnant person different than you are someone who has a different disability. And as such, that is viewed as pregnancy discrimination under the PWFA and would get you in potential trouble for discriminating against a pregnant person. Now, part 3, pregnancy or related conditions. The full scope of this is relating to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. It seems pretty straightforward, but the big area here is that it is clearly more than just pregnancy. This isn't just someone being pregnant. This is someone who may suffer a condition after being pregnant, suffering a condition relating to being pregnant, all sorts of things that could come around from it, right? So this includes things like morning sickness. Technically, morning sickness is not pregnancy. It's a condition caused by pregnancy. So if you are discriminating against someone because of, say, their morning sickness, you could get in trouble. You have to follow PWFA compliance rules on this issue. It also includes things worsened by pregnancy. Like, say, someone already had chronic migraines. Oftentimes, a pregnancy can worsen the experience of these chronic migraines, and you would still have to provide a high level of scrutiny as required under the PWFA in accommodating those migraines. Related medical conditions also includes things that involve getting pregnant. This means IVF, fertility treatments, ectopic pregnancies, termination of pregnancies. And throughout all this, there's deliberately no temporal limitation to cover medical conditions that may not be discovered, potentially even decades after a pregnancy, such as a pelvic prolapse or leukodystenia. However, in these instances, since once it goes beyond 40 weeks before or after a due date, they're going to receive greater scrutiny, and you can basically almost always say, hold on, I need to see a letter from your doctor saying that this is leaked to a pregnancy. The goal of this is that Congress is terrified that there could be some condition that is not included here, so they really want to make this language as broad as possible, while on the same hand understanding that they don't want it to be, a get out of jail free card for a potential accommodation. Last part, undue hardship. Generally, undue hardship is defined as a significant difficulty or expense considering the circumstances. Now, what does that mean? In terms of the PWFA, factors to be considered include financial resources and size of employer facility and the corporation as a whole, right? So what may be a undue hardship for, say, a mom and pop business that may have 3 employees may not be the case for a Fortune 500 company. We're also going to look at operations and location of the employer facility, right? Whereas if you work at, just a big box store or a coffee shop, maybe it's much easier to park closer to a workplace than if you are, working out in the bush or something like that. Additionally, we're going to look at the cost and scope of the requested accommodation and the impact it would have upon the employer's operations. Again, we're going to look at the individual employer in this instance. We're not going to look at, as a whole, if this was any other business. We're going to look at how will this affect the business in this instance for this business. Particularly, for requests of temporary suspension of essential work functions, we're going to be looking at the length of time, the frequency these essential functions are performed, and whether accommodations have been granted before. All right, so I know that's a lot of information, so I want to show you how this works in some case studies, right? So here is the typical case of how the PWFA should work, where a reasonable accommodation should be given, right? So in this instance, let's say there's a woman named Kaylin. She's 30 weeks pregnant, and she works at a cupcake shop as a pastry chef, right? Well, her job position includes, in the job posting, a requirement that she from time to time lift up to 50 pounds. Kaylin's doctor has asked her to not lift more than 20 pounds until her due date, right? So now we need to see if we can meet our 4 conditions, right? First, is it a known limitation? Kaylin needs to make sure that her employer knows, and so she can do this just by simply sending a text message. Kaylin texts her boss and says, hey, my doctor says I can't lift more than 20 pounds. I need to not do that in the workplace, right? Kaylin's manager knows that she is pregnant, but can here request documentation that shows the lifting restriction is tied to the pregnancy. Oftentimes, doctors will already have this as a form letter, so maybe Kaylin sends it over and says, hey, it says I can't do this. Here's the letter. But her boss doesn't have to request that information. He can also just take her word for it. Now, in this business, Kaylin rarely needs to lift much weight. Assigning lifting duty to other coworkers has been done in the past for workers with, say, back issues, and this change would only be temporary, all right? So now I can tell that, A, this is a reasonable accommodation. This is targeted to address her concern that she can't lift this much weight. So the solution here is don't have her lift that much weight. It's incredibly reasonable, and I know that there's no undue hardship. How do I know for that? I know that because in the past, this exact same accommodation has been granted to someone with a different condition, in this instance, a back pain. So here, we've met all 4 of our prongs: known limitation, pregnancy or related condition, a reasonable accommodation, and it imposes no undue hardship on the employer, and as such, Kaylin should be granted an accommodation temporarily waiving her from any work duties that would require she lift more than 20 pounds until her delivery. This is the archetypal case that the PWFA was written to address. Congress does not want pregnant people being let go of their job because they cannot perform a duty that may only come up every so often. And lifting weight over a certain amount is the classic example of that. Now let's look on the flip side, right? On a case where accommodation could be denied. So this is Sam, and she is a bartender at a cigar lounge. She recently discovered that she is pregnant and is seeking to avoid exposure to secondhand smoke. She plans on asking her manager to not allow indoor smoking of cigars on nights that she tends the bar. So it sounds like it's going to be a problem. Let's work through and check all of our points, right? First, Sam informs her manager that she is pregnant and seeking to avoid secondhand smoke. Great. She's pregnant and she has reached out to her manager. That's a known limitation. Her manager can request documentation that she is pregnant, and if it is not yet obvious, I haven't made that clear, so you can always say, hey, just making sure. Part 3, the reasonable accommodation. This is a reasonable accommodation, right? Being around secondhand smoke can negatively affect a pregnancy, so a request to avoid the smoke is reasonably addressing the problem. She doesn't want to be around smoke to ensure that there are no form of birth defects, and so she is requesting to not be around smoke, right? Reasonably related. However, as a cigar lounge, banning the smoking of cigars would likely significantly affect the operation and profits of this business. And so this very clearly poses an undue hardship on the employer. So, since we have not met all 4 of our prongs, Sam's accommodation request does not need to be granted, since it poses that undue burden on the employer. Best practices, we would like an employer to then say, hey, let's work on maybe an alternate accommodation. Maybe I can temporarily move you to a different job role, or something else of the matter to address your concerns. But the employer does not need to provide that specific requested accommodation in this instance due to the undue hardship it would have on their business. So, big takeaways from the PWFA. Number 1, you need to engage in an interactive process to find an accommodation for an employee with a limitation related to pregnancy or other related conditions. At Asher, if we get a complaint that an employee is being discriminated against on the basis of their pregnancy, one of the first things that we're going to look at is see, has the employer been engaging in an interactive process? Has an employer been saying, hey, maybe I can't do this, but I can do this? Or has an employer just stonewalled a pregnant employee on their concerns? You're much more likely as an employer to be found to have been acting reasonably if you are working with an employee on this issue. These accommodations can include temporary suspensions of essential functions of a job. This was not always the case. This is the biggest change of the PWFA. You'll say as part of his job, you may have to occasionally lift this amount of weight. You may occasionally to have to climb a ladder. You may occasionally have to be in, physical contact with blah, 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 blah. These essential functions of a job can, if they are reasonable accommodations that are not posing an undue hardship, be given as an accommodation to a pregnant employee. And it could be pregnancy discrimination if you deny this accommodation. That is the number 1 big red flag takeaway I want you to know from the PWFA. The goal is not to punish employees for things related to pregnancy. Remember, this whole thing is passed to make sure that people who are pregnant are able to work for as long as possible while they are pregnant. All right, we're going to move on now to the Pump Act requirements for employers. So employees must be allowed to take breaks to pump breast milk for 1 year following birth. While this federal law only applies to businesses with at least $500,000 in sales, regular sales across state lines, or work in the production, medical care, or education fields, AS 1880 can also mandate many of these regulations, so do not assume if you are an employer that you are exempt from these requirements. Chances are you are included in the Pump Act. So these must include breaks that either include a complete relief of duty or they are compensated. You're still paid even while you're taking this break. Employers must provide space for expression of breast milk that is at a minimum 1, a private space free from intrusion, 2, shielded from the view of public and employees, and 3, this is the most important, not a bathroom. If you come to us and say, I provided pump space, it was a bathroom, that's it. That's over. That was discrimination. You have violated the Pump Act. Nothing else really needs to be said. So again, what are these best practices here? Number 1, free from intrusion. What we would love to see here is a locking door. You could also do this by a sign indicating to knock before entering, something that says, hey, don't just, walk into this room. And this can also be temporary so long as it is respected as free from intrusion, right? So this can be, an office that was not being used. You can just throw a sign on front and says, hey, knock before entering. This is being used as a temporary pump room. Additionally, it needs to be shielded from view, ideally a separate room without windows, no security cameras or webcam monitors on it. Sometimes people try to get by with saying, yes, there's a pump room, but I need you to be on a Zoom call with your camera on. That's not how this works. That would not be meeting Pump Act requirements. Space ideally should have a place to sit, and we would love to see a table or surface to place a pump on. If it has an outlet to charge pumps and a sink to wash them off, even better. Public accommodations, so this is for not employees, but members of the public. The only entities required to have a pumping room open to just general members of the public are currently federally owned public buildings. So this includes post offices, courthouses, federal office buildings, and transportation hubs like railway stations and airports. Anything else, you don't have to have a room that's like, customers can come in and pump their breast milk there. And then briefly, just in financing and housing, AS 1880 makes it unlawful to discriminate on the basis of pregnancy or parenthood in financing and housing. This doesn't come off that often for us, but I just want to let you know that you cannot deny a loan to someone who is pregnant, someone without their spouse, or a single parent. All of that would be unlawful in Alaska. And while singles housing is lawful, so that's, housing space where you're like, hey, this is just for individuals, denying housing to pregnant people or unwed parents is not lawful in Alaska. We have gotten that case before. So with that, I want to just direct you towards further reading that may help you on these issues. There's the Pregnant Workers Fairness Act that the EEOC puts out a nice guidance doc on. They have an accommodation map that you can put up in the break room that'll drive you through, hey, if you're looking for an accommodation, here's what you should do, here's what you should do next, yada, yada, yada. The Pump Act guidance from the Department of Labor. Asher also has a number of guidance documents that are available on our website at humanrights.alaska.gov. And then if you also want to look at some of the big cases, I would point you to Thomas v. Anchorage Equal Rights Commission. With that, I just want to say a brief disclaimer that this presentation includes images and references to the creative property of others. This property is being used under a claim of fair use. It is 17 U.S.C. 107, and this presentation was created pursuant to the fair use guidelines, and further use or distribution is not permitted. Nothing in this presentation is intended to offend or ridicule any suspect class under 42 U.S.C. 1983, etc. So if you have any questions, please reach out to us. Again, I'm with the Alaska State Commission for Human Rights. Our website is humanrights.alaska.gov, and you can reach the investigations at 907-274-4692, or if you like, scan the QR code. Thank you so much for listening to this conversation, and if you have any other questions, please reach out. Have a nice day.